In the previous video, we discussed about how anti-defection law was adopted by our Indian Parliament in the year 1985. What was its journey? What defection means? How some examples like of Mr. Gayalal and Morarji Desai government collapsing due to the defection led to making of anti-defection law in the country. In this module, we will discuss about the provisions of anti-defection law which were adopted in Schedule 10 of the Indian Constitution. Anti-defection law came into force on 1st March 1985. This act not only included 10th schedule but also amended Article 101, 102, 190 and 191, which relates to vacancy of seats or disqualification of members in Parliament and in the House of People. Now, when we discuss about anti-defection law provides for disqualification of a member on the ground of defection. How a member can be disqualified? Under what circumstances he would be disqualified? We have already discussed that there are two incidents. First, when he voluntarily gives up his membership. Now, if we have to interpret what do we mean by voluntarily gives up his membership, the term is too vague. But Supreme Court in some cases has interpreted it. Like in the year 1993, in the case of Ravi Nayak versus Union of India, Supreme Court says even from a conduct of a member of a political party can decide whether the member has voluntarily gave up his membership. Similarly, in the case of G. Vishwanathan versus Honorable Speaker, Tamil Nadu Legislative Assembly, Madras and others, Supreme Court held that even from the conduct of a member, like his views in the news reports, on the media channels, etc., can be interpreted that he has voluntarily gave up his membership. To further explain, meaning when one member of a political party favors the policies and agendas and viewpoint of another political party but not of his own, that would be included in his conduct, meaning he has voluntarily gave up his membership, as the Supreme Court has interpreted in the case of Ravi Nayak and G. Vishwanathan. The second ground on which a member of a political party can be disqualified is when that member votes or abstains from voting. Please note, there are both the circumstances. He votes or abstains from voting against the wishes of his political party, against the directions which is issued by his political party. Though there is a slight exception to that, which is when a member has taken prior permission from his political party that he would not vote or abstain from voting, that he would vote or abstain from voting against the directions of the political party. if that prior permission has been taken, he would not be disqualified. According to Member of Lok Sabha, Disqualification on the Ground of Defection Rules 1985, the member of the political party has to take the permission within 15 days. Once this permission is taken by the political party, it has to be notified to the speaker within 30 days from that voting. So with this, we are clear that there are two grounds of disqualification. The first is voluntarily giving up his membership. Second is voting or abstains from voting as per the directions issued by his political party. Now, when we talk about disqualification, the date of the disqualification would be the date on which incident has taken place and not on the date the order of disqualification was passed. The power to decide disqualification under the Indian Constitution is provided to the Speaker or the Chairman of the House of People. Speaker and Chairman can decide the matter of disqualification only when they receive complaint against the member of a political party. They cannot take suo motu action. Now, when they decide the matter, they act as a tribunal. But the order passed by the Speaker or the Chairman is subject to judicial review under Article 32(2)26. With this, we have discussed the grounds of disqualification of a member of a political party and who has the power to decide that. But let us discuss what is the scenario in case of independent member or a nominated member. In case of an independent member, if that independent member after he gets elected joins any other party, he would be disqualified on the ground of defection. But in case of nominated member, he can join any political party within 6 months from his election. After that, he would also be disqualified. But if he joins any political party within a period of 6 months, he would be considered as independent member. Supreme Court, in the case of Kihoto Holohan versus Zakilu in the year 1993, gave a restricted meaning to the term directions issued by the political party. According to the Supreme Court, there are only two matters on which a political party can issue a direction. That is, when there is a vote on motion of confidence or no confidence in the government, and second, when the motion is with respect to party policy, programs on the basis of which it was elected. The Supreme Court gave the restricted view of the term directions issued by the political parties while considering the freedom of speech of member of a political party as given under Article 105 Clause 1 and 194 Clause 1. Now let us discuss few examples of defection that had taken place after 1985, that is after passing of the anti-defection law in the country. In the year 1998, Supreme Court decided a matter. The name of the case was Mayawati versus Markande Chand and others. The brief facts of this case are that in 1996 a coalition government was formed between BSP and BJP. Representative of BJP, Mr. Kalyan Singh, was made the Chief Minister of UP. Subsequently, BSP decided to remove his support to the BJP. A direction was issued by Mayawati to his party members to not to support BJP when they have to prove the majority in the House. However, 12 members of BSP supported the BJP. Subsequently, out of the 67 members of BSP, there was a split. 26 members splitted and formed a new party, Janatantrik BSP. Later on, there was split in that also. So 19 members remained in Janatantrik BSP and 7 joined the Mayawati BSP again. But when the question of disqualification on the ground of defection reached the Supreme Court, the Supreme Court decided that BJP was having majority even in the absence of support of these 12 BSP members. But even then, whether their support mattered or not, even then they did not follow the directions issued by the political party. They violated the wishes of their political party. Thus, they should be disqualified, leading into disqualification of those 12 members of BSP on the ground of defection. Similarly, in March 2016, Uttarakhand Chief Minister Harish Rawat approached the Speaker to disqualify 9 rebel Congress members. Later on, they were disqualified on the ground of defection. In this video, we discussed about the grounds on which disqualification can be given to a member of a political party in case of defection. How disqualification can be given to an independent member. What happens for nominated members. We also discussed certain examples of defection that had taken place in the country after 1985. In the next video, we'll discuss about floor test, merger of political party, exceptions and more.